This week, Luxembourg, major developments from the CJEU. On 8 July, the joint cases known as Apple versus Commission were decided. Apple had challenged its designation as gatekeeper by the European Commission under the Digital Markets Act.
The court dismissed Apple's action, something that will have consequences on how iOS, the App Store, and iMessage are run.
And the CJEU's activity doesn't stop here. On 9 July, the court delivered an important copyright ruling in Anne Frank fonts.
If a work is publicly accessible in one member state, it may be made available online, even if it's still protected by copyright in other countries in the EU.
But there is a condition. Providers must implement effective geo-blocking measures to prevent access from member states where protection still applies. What a week for cross-border digital publishers!
Taking a step into regulatory waters, the European Data Protection Board adopted 2 new guidelines on July the 8th, opening for consultations until October the 30th, 2026.
The much-awaited new guidelines on anonymization provide a practical framework to determine when data can truly be considered anonymous.
On the AI side of data protection, guidelines on web scraping and generative AI address the scraping of online data, whether done internal or through contractors, in the context of AI training. The guidelines are deemed to reconstruct data protection and copyright law principles in light of a more innovation-friendly EU-wide tech policy.
And last but not least, brace yourselves, as the CJEU is not done yet with its ruling agenda. The upcoming decision in NADA Austria will redefine the boundaries of the public's right to know in the digital age. We promise it will be short.
And to the point.